You've seen the headlines, right? Amazon, Dell, JP Morgan. It feels like every day another big company is calling everyone back to the office. And look, for so many people, especially if you're managing a medical or mental health condition, this isn't just some small inconvenience. It's a huge source of anxiety. It can really feel like you're being forced to pick between your health and your job. So let's just dive right into this.
So the big question on everyone's mind is, when that company-wide email hits your inbox, is that it? Is that mandate the absolute final word? I mean, it's easy to think it is, but the answer is way more interesting and honestly, a lot more empowering than you might think.
And that's because there's a powerful federal law called the Americans with Disabilities Act, the ADA, and it actually sits above your company's policy. It means a blanket mandate doesn't just get to steamroll your individual rights if you have a qualifying health condition. And that right there is the key thing we're going to break down in this explainer. Okay, so let's get into this core conflict, right? You've got the company wanting this one-size-fits-all policy on one side, and on the other, you have your legally protected rights under the ADA. Here's how it works in practice. A company can totally set a general return-to-office policy for everybody, but, and this is a huge but, the ADA requires them to take a step back from that big rule and actually look at individual requests for accommodation, one by one. They can't legally just have a blanket no exceptions rule when an employee's disability means they need one. It's all about individual needs, not a cookie-cutter approach. And listen, this isn't just some clever new take on the law. The Equal Employment Opportunity Commission, that's the federal agency that literally enforces the ADA, they've been crystal clear about this. They have officially stated that employers have to consider working from home as a reasonable accommodation for a qualifying employee, even if the company doesn't usually offer remote work. All right, so that brings us to the most important question, right? Who actually qualifies for this protection? Let's take a closer look at what the ADA covers, because honestly, it's a lot broader than most people think. The official legal definition here is a physical or mental impairment that substantially limits one or more major life activities. Now, the key phrase to focus on is substantially limits. This isn't just about having a visible disability. It's all about how a condition actually impacts your ability to function day to day. And this law covers a massive range of conditions. We're talking about things like anxiety and depression, ADHD, PTSD, even chronic pain from something like migraines or fibromyalgia or autoimmune disorders. The main thing to get here is that so many of these conditions are invisible, but they are absolutely 100% recognized and protected by the ADA. And get this, here's another super important detail. Your condition doesn't have to be impacting you 24/7 to be covered. The ADA also protects conditions that are episodic, meaning they flare up, or even ones that are in remission. As long as the condition would be substantially limiting when it's active, it can still qualify. Now, let's talk about something huge that's working in your favor right now. You have this really unique strategic advantage that just didn't exist before 2020. Seriously, in this case, timing is everything. This timeline just lays it all out perfectly. Before the pandemic, the go-to argument from employers was that a job simply couldn't be done from home, that it would cause an undue hardship. But from 2020 on, well, millions of us proved them wrong, day in and day out. You've basically created years of hard evidence for your own employer that it not only works, it works well. That precedent you set is fresh, it's powerful, but that window of proof isn't going to stay open forever. So, if you decide you want to move forward with this, what are the rules of the game? It's really important to get that this is a formal, two-way street. Both you and your employer have specific responsibilities. This chart breaks it down so well. Your employer can ask for medical documentation to support your request, and they can propose other ideas, maybe a hybrid schedule or something else. The whole point of the law is to find a solution that works for everyone. But what they cannot do is just say no without having a real conversation with you. That's called the interactive process. And crucially, they can't punish you for even asking. Now, it's also important to know they can ultimately deny a request if it truly causes an undue hardship, like a fundamental change to the business, but the burden is on them to prove it. All right, let's turn all this legal talk into a real practical game plan. If you think this might apply to you, here's exactly how you can start the process to protect your rights. It really comes down to 3 simple but incredibly powerful steps. First, start early. Don't wait until the week before you're supposed to be back in the office. Second, get your documentation. A solid letter from your doctor or therapist is probably the single most important piece of the puzzle. And third, put everything in writing. Use your email for all requests and follow-ups. You want to create a crystal clear paper trail. So, when you boil it all down, here's the bottom line. The ADA was literally created for situations just like this. It exists so that people with real health conditions don't have to make that impossible choice between their well-being and their paycheck. Using this process isn't about finding a loophole. It's about accessing a legal protection that you are entitled to. Just knowing this information completely changes the conversation around these return to office mandates. It shifts the power dynamic and gives you a real seat at the table. So, the real question is, are you ready to use your rights?